Hello everyone, my name is Geetanjali Singh and I am currently interning at LEXIS and Company, and in today's video we'll learn about the general exception that comes under IPC under section 84 as insanity. Now for first we will introduce what is insanity and its origin, and then Indian laws regarding it and the cases relating to it. Now, first of all, to introduce insanity, it is a defense in India that remains an unsolved problem in criminal jurisprudence. However, it presents some fascinating problems that deserve careful analysis and their mental check. Now, there is a well established principle called actus non facit reum nisi mens sit rea, which means in literal sense that an act done not make any offender liable without a guilty mind. That is the intention or a guilty mind that we call mens rea under Indian Penal Code of the offender is an integral part while committing a crime. Now, the whole defense of insanity is the law that protects a person who is incapable of understanding the nature of the act done by him and upon whom the mens rea, that is the criminal intention of committing a crime, is absent. Now, the unsoundness of mind is not clearly defined under any law, that what is unsoundness of mind and what contains it and what when it cannot be used as defense, and it should be of such extent that it makes the offender completely incompetent in knowing the nature of the act and the thing that he has been doing. The factor that the person is suffering from a mental illness is itself is not sufficient to prove that he is insane. For example, if a person is suffering from a mental condition but he has that same sane mind, that he knows what will be the consequences of the act that he is doing, it he cannot be able to use the exception that has been come under the Indian law. Now, the rationale of insanity as defense is incorporated under section 84 of our Indian Penal Code 1860 and is based upon the famous McNaughton's rule. We'll discuss about the McNaughton's rule in further video, and the burden of proof is always on the defendant, that it has to prove that beyond any reasonable doubt that they are not of sound mind, and they did not knew the consequences that has been followed up committing a crime. Now, it under English law, when the first case which dealt the law of insanity was in 1724, and the case was R versus Arnold, in which Edward Arnold attempted to kill and even wounded Lord Onslow and was tried for the same. Now, evidence clearly showed that the accused was suffering from a mental disorder, and it was said and observed that if he was under the visitation of God and could not have been distinguished between good and evil and did not know what he did, though he committed the greatest offense, yet he could not be guilty of any offense against any law whatsoever. Now, incapability of distinguish between good and evil and did not know the and not knowing the nature of act committed by him, this test was known as wild beast test. There were several tests before McNaughton's rule, and in the second test, it involved in the Hadfield's case of 1800, where it stated that insanity was to be determined by the fact of fixed insane delusion, and that such delusion under which the defendant acted is the main reason for his crime. Now, this test was also known as insane delusional test, where a person is under a delusion that what he has been doing, he did not know the repercussions and the consequences of the same. Now, finally, there was a third test which formulated in Bowler's case of 1812. In this case, the judge Leblanc stated that the jury has to decide when the accused committed the offense, whether he was capable of distinguish right from wrong or under the control of an illusion. After the Bowler's case, the court has placed an emphasis on the capacity of accused to distinguish between right from wrong, though the test was not that clear. Now, there was another case in which there were 15 judges, and out of 15 judges, 14 judges had the same answer, and the view of majority was given by Tyndall And the answers to the question are known as Macnaughton's rule. And the Macnaughton's rule contains four principles that must be dealt and must be kept in mind to declare a person of insanity. Now, first of all, if the person knew what he was doing, or was only under a partial delusion, then he is punishable. If there is an assumption that every man is prudent or sane and knows that he is doing and responsible for the same, he must be punished. And to establish a defense based on insanity, it must be ascertained at the time of perpetrating the act, the accused was in such a state of mind as was unable to know the nature of the act that has been committed by him. And the last was a person who has sufficient medical knowledge or is a medical man and is familiar with the disease of insanity cannot be asked to give his opinion if the jury to determine decides upon the question. Now, the Indian law on the defense of insanity says, and it provides that in accordance to section 84 of Indian Penal Code as defense under Indian law, however, the term insanity is not used under the provision, but the term and the code uses that mental soundness. Now, in accordance with this code, the defense of insanity, or can also be called a defense of mental insanity, which comes under Macnaughton's rule. And under section 84 of IPC, a person of unsound mind shall act nothing in an offense committed by someone who is currently unable to know the nature of the act, what is, or does not know what is wrong or contrary to legislation due to the lack of sound mind. And nevertheless, it should be noted that framers of IPC prefer to use the expression of insanity of mind instead the term of insanity, because the insanity scope is really limited, while the mind's insanity covers a large area and can be see-through. Now, for this defense, the following elements are to be established. Now, the accused was in state of unsoundness of mind at the time of the act, and he was unable to know the nature of the act or do what was either wrong or contrary to the law, and the term wrong is different from contrary to law. That was all. Thank you. We'll deal with the cases and in another part. Thank you.